At 9:17 on a gray Thursday morning in Stamford Superior Court, the room was already tight with the kind of silence that makes people stop shifting in their seats. Judge Raymond Harlan had just begun reading from the sentencing file when the girl at the defense table leaned back, crossed one polished heel over the other, and let out a small laugh. Not nervous laughter, not disbelief, the other kind, the kind meant to be heard. 19-year-old Sloane Mercer turned toward her mother, touched the corner of her mouth with one manicured finger, and whispered, just loud enough for the front row and the court reporter to catch it, "He's really doing the whole speech." It landed like broken glass. Miguel Santos, the man whose pelvis had been crushed under the front end of her Mercedes 8 months earlier, was sitting 10 feet away with a steel brace under his trousers and a cane against his chair. His wife froze. The prosecutor looked up. One of the marshals took a half step forward. And Judge Harlan, a former homicide prosecutor who had spent 28 years on the bench and had long since stopped confusing arrogance with youth, removed his glasses and stared straight at her. That should have been the moment the story ended. A rich teenager humiliates herself in court. Judge gets angry. Contempt warning. Headlines by noon. But that was not this case, because what looked at first like one grotesque courtroom mistake was actually the final crack in something much larger. By that morning, this was no longer just about a reckless girl in a $186,000 SUV. It was about what happened after the impact. It was about who got called before 911. It was about erased messages, a washed bumper, a witness who suddenly changed his story after a payment hit his consulting company, and a family so used to bending institutions that they mistook patience for weakness. If you appreciate stories where power finally meets consequences, stay with this one, because the laughter was only the surface. The real destruction had started months earlier, and Judge Harlan already had the full file in front of him. The crash happened on February 14, 2025, at 11:42 p.m. at the intersection of Washington Boulevard and North State Street, 3 blocks from the old post office and less than a mile from the Mercer family's riverfront condo. Cold rain had been falling for hours. Traffic was thin. Miguel Santos, 42 years old, a licensed electrician and father of 2, was driving home in a white Ford Transit van after an emergency service call at a bakery in Darien. He had texted his wife at 11:31 that he was on the way and asked if their younger son was still awake. Sloane Mercer had spent that evening moving through a very different map of the city. First a charity gala at the Delamar, then a private after-party at a penthouse on Broad Street, then a stop at a parking garage where cameras later showed her climbing into the driver's seat of her black Mercedes-AMG G63 in silver heels and a cream wool coat. Her blood alcohol level would later become a matter of legal dispute. Her speed would not. The vehicle's own data recorder showed the SUV moving at 76 miles per hour in a 35-mile zone 5 seconds before impact. No braking, no evasive steering. Full throttle for nearly 2 full seconds after the light turned red. When the G-Wagon hit Miguel's van broadside, it spun the smaller vehicle across the intersection and into a traffic signal pole hard enough to shear metal. Witnesses said the sound echoed up the wet buildings like a gunshot. Then came the detail that changed the moral temperature of the case. The Mercedes did not stop. It lurched, corrected, dragged part of its own front fascia through the crosswalk and kept going south. Miguel Santos was alive, barely, his left hip shattered in 4 places, 3 ribs broken, internal bleeding, nerve damage that would later leave him unable to climb ladders, unable to kneel, unable to return to the kind of work that had supported his family for 18 years. A delivery driver named Terrence Cole called 911 at 11:43. Sloane Mercer called her father at 11:44. That 1-minute sequence became the spine of everything that followed. Grant Mercer was not simply a wealthy father. He was the founder of Mercervale Capital, a hedge fund with offices in Greenwich, Midtown, and Miami Beach, and the kind of donor footprint that gets your name on museum walls and your calls returned. By 12:08 a.m., And before detectives had even identified the fleeing vehicle, the Mercer family's longtime attorney had made 3 calls, a private security driver had been dispatched to the condo garage, and a building porter had been told to expect a damaged vehicle. By sunrise, the front of the Mercedes had been rinsed. Not repaired, not hidden. Rinsed. That seemed minor until investigators understood what had been washed away. At first, the defense tried to turn the case into something softer, blurrier, more survivable. A terrible accident, a frightened young woman, confusion, trauma. Maybe someone else had been driving. Maybe the impact made memory unreliable. Maybe the media was making an example out of a 19-year-old girl because her last name was Mercer. The usual scaffolding went up fast. A treatment program in Arizona, character letters from school administrators, a therapist retained within days, a publicist stressing privacy, youth, promise. The problem was proof. Stanford police were clumsy in the first 48 hours, but not blind. Detective Lena Ortiz noticed almost immediately that the timeline being floated by the family did not match the building's entry logs. Sloan told officers she arrived home around midnight in an Uber after leaving her vehicle downtown, but keycard records showed the Mercedes entering the underground garage at 11:51 p.m. Elevator footage showed Sloan stepping out of that garage level at 11:53, carrying her heels in one hand and her phone in the other. Not crying, not disoriented, not on the phone with emergency services. She looked irritated. Then investigators subpoenaed the vehicle data. The seat memory setting at impact was Profile 2, configured weeks earlier for a driver 5'4". Sloan Mercer was 5'4". Her boyfriend at the time, whose name briefly circulated online as the possible driver, was 6'1". The steering wheel distance, brake pedal position, and side mirror adjustment all matched her saved settings. Airbag residue taken from the driver's side door panel contained a mixed DNA profile, but her profile was the major contributor. And 1 minute after the crash, the phone linked to the Mercedes infotainment system unlocked with Face ID and sent a text. Not to 911, not to Miguel, not even to a friend, to the house manager. Open garage, need towels. That was when the story stopped being ordinary, because a panicked teenager fleeing an accident is one kind of defendant. A defendant who begins managing the cleanup before the victim is even in an ambulance is another. And once prosecutors understood that, they stopped treating the case like a tragic lapse and started building it like an obstruction file. Miguel Santos gave his first statement from a hospital bed at Stamford Hospital 3 days later. He did not know who had hit him. He remembered the red light, the white-green glow on wet pavement, then a wall of black metal and headlights. He remembered trying to move and realizing he could not feel part of his left leg. He remembered asking the EMT whether he was going to lose his job. His wife, Elena, sat beside him holding a folder of insurance forms and hospital estimates that were already climbing past $84,000. Their older son, Adrian, was studying HVAC certification at Norwalk Community College and had started taking extra shifts at a grocery warehouse. Their younger boy stopped sleeping through the night. These were not abstract damages. This was rent, medication, missed work, school deferments, the humiliating arithmetic of catastrophe. And all the while, the Mercer camp kept behaving as if time was on their side. There was the boutique rehab program, the carefully lit courthouse arrivals, the sealed motion asking the court to consider Sloan's developmental immaturity and acute stress response. There was even a package of letters describing her as compassionate, service-minded, exceptional with children. But prosecutors began to notice something else. For a girl allegedly overwhelmed by the trauma of what she had done, Sloan was remarkably active when she thought nobody with authority was watching. She posted from Aspen during a bond period that prohibited non-essential travel. She appeared in a friend's TikTok at a rooftop party in Miami, while defense counsel was telling the court she was in intensive treatment. And in one deleted group chat recovered from her phone, she answered a friend asking whether she was scared of prison, with 5 words that would later echo through the courtroom. "My dad doesn't do prison. If you believe no one is above accountability, keep listening, because that sentence did not just expose attitude, it exposed expectation. The center of the case arrived in a 47-page supplemental filing submitted 10 days before sentencing. It was dry on the surface. Metadata, subpoena returns, financial exhibits, a transcript from a forensic extraction. But buried in that filing was the one sequence the defense could not explain away. At 11:44 p.m., 2 minutes after impact, Sloan called Grant Mercer. At 11:46, Grant Mercer forwarded a message to his chief of security. "Get downstairs, no police." At 11:49, Sloan texted the house manager. "Front is smashed. Need it cleaned before morning." At 12:07 a.m., $15,000 was authorized from a Mercer family office account to a consulting firm called North River Advisory. 3 days later, North River Advisory paid $9,500 to Terrence Cole Enterprises, the single-member LLC of the delivery driver who had originally told police he saw a young blonde woman behind the wheel. A week after that payment, Terrence Cole revised his account. Suddenly he was unsure. Maybe the windows were tinted. Maybe it was a man. Maybe he had been too far away. That was the moment the entire case changed shape. This was not just privilege, it was process. It was a system of reflexes built from years of success where money moved first, facts got softened second, and decency came last if it came at all. Prosecutors did not have to prove every dollar was a bribe. They only had to show the court a pattern of intervention so aggressive and so immediate that leniency became morally absurd. And then investigators found the message that made intent undeniable. It had been deleted from Sloan's phone, then partially recovered from a cloud backup fragment. It was sent to a friend at 12:19 a.m., while Miguel Santos was still in surgery. "I didn't stop because I knew they'd make me the villain." No apology, no fear for the man in the van, no shock, just self-protection. The entire world in her mind had already arranged itself around her image. Defense counsel tried hard. She argued youth. She argued shame expressed privately. She argued that family interference should not be laid at the feet of a teenager. She pointed to treatment, philanthropy, academic records, the pressure of growing up in public. She said Sloan had accepted responsibility by pleading guilty to evading responsibility, causing serious physical injury, and tampering with evidence. She urged a suspended sentence, home confinement, community service, psychological monitoring. She said prison would destroy a young life. What the state said in response was colder and far more dangerous. Assistant State's Attorney Nora Bell stood up, touched the podium once, and reminded the court that prison is not designed to preserve a young life exactly as it was. It is designed to answer what was done with it. She listed the facts one by one: speed, impact, flight, cleanup, deletion, witness contamination, bond violations, social media deception. Then she said the line that shifted the room. "This defendant has mistaken affluence for insulation at every stage of this case. The court should not make the same mistake." By sentencing week, the gallery was packed. Reporters lined the side wall. Law students sat behind retirees and court regulars who could sense a live wire when they saw one. Sloan arrived in beige cashmere and a navy coat with no visible expression, the kind of expensive blankness people mistake for composure. Her mother cried before the hearing started. Her father did not. He sat very straight, jaw locked, hands folded, as if posture itself could still control the outcome. Miguel Santos spoke first. He did not raise his voice. He did not perform pain. He simply described the geography of his life after February 14th, the metal rail in his shower, the mortgage modification packet, the way his younger son watched him struggle to tie a work boot he no longer had reason to wear, the way people said he was lucky to be alive as if survival settled the account. Then he looked directly at Sloan Mercer and said, "You left me in the road like I was the dangerous thing." That should have broken something in her. Instead, she smirked. Not a dramatic movie smirk. Worse. A tiny, impatient curl of the mouth, the expression of someone being forced to sit through consequences they still do not believe are real. Her mother noticed and grabbed her wrist. Too late. The reporters saw it. The Santos family saw it. Judge Harlan saw it. Then came the whisper. He's really doing the whole speech. People would later say that was the moment the courtroom turned. That is not quite true. The courtroom had already turned on the evidence. What changed in that instant was not the law. It was the mask. Sloan Mercer had spent months presenting a curated version of herself. Sober, humbled, chastened, learning. In 5 careless words, she destroyed the only remaining argument that punishment should be softened by remorse. Judge Harlan did not snap. That is what made it devastating. He removed his glasses, asked the clerk to mark the defendant's courtroom statement for the record, and then asked a question so measured it sounded almost gentle. "Ms. Mercer, do you believe this proceeding is beneath you?" Her lawyer shot up immediately. "Your Honor." He silenced her with one raised hand. Sloan, who had never understood the difference between being watched and being evaluated, made the fatal choice of answering. "No, Your Honor, I just think everyone is being a little dramatic about an accident." There are courtrooms where that line might have dissolved into crosstalk, not this one. In Harlan's courtroom, the silence after she said it was complete. Then the judge reached for the supplemental file. He began reading not from outrage, but from record. He read the seat position data. He read the timing of the call to her father. He read the transfer of funds connected to the only civilian witness who had changed his account. He read the bond violation photographs stamped with dates and locations, showing her in Aspen and Miami, while the defense described strict therapeutic isolation. He read the deleted message about not stopping. He read her group chat line about prison, and finally he read her statement from 5 minutes earlier. When he looked up again, the girl who had mocked him was no longer leaning back. She was sitting very still, eyes wide, as the architecture of her protection collapsed in public. "This court has considered your age," he said. "It has considered your resources, your treatment, your educational prospects, and the arguments presented on your behalf. What it cannot ignore is that at every fork in the road, you chose concealment over courage, image over duty, and advantage over human life. Even now, with the man you crippled seated a few feet away, you call this drama. It is not drama, Ms. Mercer. It is character under oath." Then he sentenced her. 9 years on the primary count, consecutive 3 years on tampering, execution suspended after 8 years to serve, followed by 5 years of probation, permanent loss of license eligibility for the statutory term, restitution to be determined, immediate remand. For a second, nobody moved. Even seasoned court reporters paused because they understood the difference between a stiff sentence and a definitive one. Sloan's mother made a sound people in the back would remember for weeks. Grant Mercer stood up as if reflex had outrun judgment, and a marshal immediately told him to sit down. Defense counsel asked for a stay pending appeal, denied. Asked for a brief surrender window, denied. Asked for consideration of a medical unit placement due to anxiety treatment, to be addressed by corrections, not this court. And then the shock that gave the case its final edge. As marshals moved toward the defense table, Judge Harlan added one more order. Certified copies of the evidentiary findings and financial exhibits were to be transmitted to the State Attorney General and the U.S. Attorney's Office for review of potential obstruction, witness tampering, and financial crimes arising from third-party conduct. In plain English, the court was not done with the Mercers, not even close. That was the part no one in the family had prepared for. Prison for Sloan was already catastrophic in their world. Federal review of the machinery around her was something else entirely. Within 48 hours, North River Advisory's office was served with subpoenas. Terrence Cole retained counsel. 2 former Mercer security employees sat for proffer interviews. Mercer Vale Capital announced that Grant Mercer was taking an indefinite leave of absence, which is the corporate phrase people use when the walls are closing in and everyone knows it. Sloan's deferred admission to Columbia was withdrawn. A children's hospital removed the Mercer name from a donor recognition event scheduled for spring. Suddenly, the family that had spent years buying visibility wanted nothing more than privacy. Miguel Santos did not get his old life back. That part matters. Viral stories like to flatten justice into a clean trade. a sentence in exchange for harm, a gavel in exchange for pain. Real cases do not work that way. 8 years in prison does not rebuild cartilage, restore nerve endings, or give a working father back the body he had on a cold February night. Elena Santos still had to manage appointments, bills, insurance fights, and the daily insult of watching wealthy strangers call the sentence excessive from the comfort of lives uninterrupted by impact. But something real did happen in that courtroom. The lie broke. The oldest lie in cases like this is not that the defendant is innocent. It is that the system is too soft, too dazzled, too compromised to recognize contempt when it arrives in expensive clothing and speaks in a polished voice. On that morning, in one wood-paneled room under fluorescent lights and state seals, that lie failed. Not because the judge was offended, because he was disciplined, because he waited, because he let the evidence become heavy enough that when judgment came, it did not look emotional, it looked inevitable. In the weeks after sentencing, one image kept circulating. Not the crash scene, not the family, not the courthouse steps, but the final 6 seconds before the side door closed behind her. Sloane Mercer, who had spent months appearing in curated photos with perfect posture and practiced detachment, turned once toward the gallery as if she still expected someone to interrupt reality on her behalf. Nobody did. The marshal touched her elbow. She disappeared into the holding corridor. The door shut. And for the first time in the entire case, there was no spin left to apply. If cases like this make you think, say so, because they should. What made this story unforgettable was not that a rich girl mocked a judge. It was that she believed the courtroom was a stage where consequences could still be negotiated after the facts were known. She thought authority was theater. She thought remorse was styling. She thought injury could be reframed if the people around her were expensive enough. She was wrong, and in the end, that is why the case stayed with people, not for the outburst, not even for the sentence, but for the final contrast it left behind. One man learning to walk again in a brace he never asked for, and one young woman learning too late that the law does not become smaller just because your life has always been large. In the road on the record, under oath, character always arrives, and when it does, it speaks louder than money ever can.